Hi, I'm Brian Heidelberger, a partner with the law firm of Winston & Strawn in Chicago, and here today with another mini advertising law lesson. Today's law lesson is why U.S. brands and agencies should care about GDPR and what GDPR actually is. But first, you may recall from my last video that I've come up with an ingenious plan where I keep churning these videos out, but I do less and less work. And how is that? That's by introducing you to some of my colleagues. Today, it's going to be my partner, Rob Newman, co-chair of the firm's privacy and data security practices, and Rob's going to answer all the questions and do the heavy lifting here on GDPR. So, Rob, can you tell us what exactly is GDPR?
The GDPR is a new set of sweeping regulations in the EU that will impact how companies can process, collect, use, and share personal information relating to EU residents. U.S. companies are now considering how to come into compliance ahead of the May 2018 effective date.
And Rob, tell us, why should a brand care about GDPR?
Jurisdictional issues aside, if you are collecting information from or about an EU resident, the European regulators take the position that the GDPR will apply to you. So U.S. brands who might have a website that's directed to the EU or have an e-commerce site with customers in the EU need to start thinking about GDPR compliance now.
And why should a U.S. agency care about GDPR?
The GDPR will certainly apply to U.S. advertising agencies, again, at least in the eyes of the EU regulators. The GDPR applies to both controllers and processors. Controllers are those companies who make decisions about how information is used. Processors, on the other hand, take direction from the controller. So an advertising agency or a media buying agency might function both as a controller and as a processor. And if you have information about an EU citizen, then the EU will take the position that GDPR will apply to you. We've heard particular concern from marketing technology companies who might have no direct contact with any of the individuals for whom information they have.
Oh, awesome.
And the problem there is that under GDPR, at least in many instances, consent is going to be required from the individual before their information is processed. And that leaves open the question, well, how do you do that in an environment where you have no direct access to those consumers?
So, Rob, why should agencies care about GDPR?
At its core, GDPR applies to personal data. This concept of personal data, like in the US, can be a little bit difficult to pin down, but I think the default here should be that it's rather expansive. So GDPR essentially defines personal data to mean any information that can be used to directly or indirectly identify or contact an individual. Notably, this includes things like an online identifier like an IP address or some cookie information, particularly in cases where that information can be used to build a profile about an individual.
So, Rob, what do U.S. brands and agencies have to do now with respect to GDPR?
There are several steps that a company needs to take to come into compliance with the GDPR. But here are three key ones. First, conduct an audit. Second, figure out how you're going to provide individuals with access. And third, figure out how you're going to get consent for the use of the individual's information. So first, on the auditing front, conducting a data map or somehow figuring out what type of information you have, where it's coming from, how and why it's being used can really allow your organization to focus on the important pieces of your database. Second, with respect to access, individuals under the GDPR will have significant ability and rights with respect to the data you have about them. So if you have information about me, I can ask you to forget me, to delete me, to modify the information. And for a lot of companies, that poses significant challenges because you might not know where all that data is sitting or have any way of actually accessing the data in response to such a request. And then finally, with respect to consent, under the GDPR, actual opt-in consent is going to be needed from individuals in many instances. And that's different from the EU environment today. So companies will want to start thinking about how that consent will occur in a post-GDPR world.
So, should people freak out?
Probably, though not really. So everyone is talking about how significant the penalties are under GDPR. $20 million. 4% of the global annual return, but I don't think anyone is really expecting the data protection authorities to come after companies for that amount of money in year one. Instead, I think companies should focus now on learning what data they have, figuring out how they can get the consents that they need to have in the future, and doing their best to come into compliance prior to May 2018.
So I hope this information was helpful. Thanks again to my partner, Rob Newman, co-chair of our firm's privacy and data protection practice. Sorry, Rob, no drink for you. But until next time, let's be careful out there.